Good evening, everyone, and welcome to our public lecture, the second one of our mini-series that was going to be connected to our ICS 3D summer school. The summer school, sadly, is not running because of the pandemic situation. But both our keynote speakers have very nicely agreed to give their keynotes as public lectures. We had Matthew Nichols 3 weeks ago, and we have today Andrea Wallace that will talk about digitization, intellectual property, and restitution, exploring more equitable approaches to digital cultural heritage management. I hope that I conveyed the creativity of the type fonts and this title. So before we start, I would like to say just a few words to introduce Andrea, who is a senior lecturer at the University of Exeter in the law department. And she works at the intersections of copyright, cultural institutions, and the public domain. Research considers the impact of digital technologies on the preservation and dissemination of cultural heritage and the obstacles and opportunities presented by the digital realm. So Andrea is actually an old friend. She has been part of our Synoikis seminars a few times, and she's one of our most beloved speakers. And I am absolutely delighted to give her the floor for this talk. Thank you, Andrea.
Well, thank you for having me. It's a nice consolation, given that we can't all be together. But I'm very glad that this is still going on. So, let me just get my screen ready. And I'll kick it right off. So my presentation is it's on digitization, intellectual property, and restitution. And as Valeria mentioned, there's some kind of subtle, not so subtle insertions into the title when we're thinking about what equitable approaches are, obviously trying to get to something that's more equitable, but also about how digital cultural heritage and material cultural heritage are so intertwined with each other that we really cannot separate them anymore. But the point being that digital cultural heritage is often considered to be an afterthought. So it's not brought in with a lot of the policies when we're thinking about restitution of physical materials. So I thought I'd start by kind of grounding the presentation in these two images. So we have these looted bronzes from the Kingdom of Benin, which you may recognize because these two specific images have been very widely circulated in recent articles on the restitution of sub-Saharan African cultural heritage. And the reasons for this is that these two images are actually copyright free. So both have been released via the CC0 public domain dedication tool. One is held and reproduced by the Metropolitan Museum of Art, and the other by the Cleveland Museum of Art. Now, this caption doesn't include the public domain status. Instead, it uses standard terminology to signal that the image has been made available courtesy of, which implies fee-free. But not all materials generated during the reproduction of a work will be subject to copyright, nor might all the materials similarly be suitable for open access. And at the moment, there's less attention being paid to the digital aspects of heritage ownership, authorship, and commercialization, which can have a particular set of consequences when we start to think about manifestations of culture that are fit for repatriation. So to guide us through this discussion, we'll start with copyright, kind of looking at when it arises, when it doesn't, and what either of those outcomes entail. And then we'll turn to the restitution aspects and examine both material and digital aspects of repatriation, as well as the concept of IPR repatriation, which my colleague Mathilde Pavis and I are working on and are kind of developing further into a couple of papers. So I hope by the end of this, you agree that digital should not be an afterthought when we're designing restitution and repatriation policies. And instead, it needs to be embedded and may even require additional legal reform in order to accommodate more equitable approaches to both digital and material cultural heritage management. So to begin, copyright, when it arises, when it doesn't, and what either of those outcomes entails. So a brief introduction into the basics. Copyright protects original works of authorship. Now we'll keep coming back to this, but in our case, we're concerned not about the underlying work at this point, because copyright may actually prevent a work's reproduction in the first place, unless that work that's being digitized, the copyright is expired and it's in the public domain. So we're just going to assume that this is the case, which means that what we're really focusing on is the digital media that's generated around the public domain cultural heritage. So we're asking, is that media in any of its components and forms original enough to become a new work of authorship? Because if so, the term of protection will be the life of the author plus 70 years, which means if the author dies today, the digital media will pass into the public domain in 2091. That's a really long time when we're talking about digital. But during that term of protection, the rights holder is entitled to a monopoly, and they can leverage the access to the digital media via a fee or through a license. Now, depending on the jurisdiction, the public may be able to access the digital media if it has been made publicly available via certain exceptions and limitations that are in national copyright law, like a personal study or educational purpose exception. But copyright is also accompanied by moral rights, like the right of attribution to be associated as the author of the work, or the right of integrity to prevent derogatory treatment or modification of the work. And then in some countries, these rights are perpetual, which means they will never expire. Another important aspect is that copyright is automatic. It attaches the moment an original work is fixed in a material form. Accordingly, the key question, and what we'll keep coming back to, is whether the digital materials are sufficiently original to attract a new copyright in the first place. This is a very low standard to meet, but it's essentially a legal question. And it requires a court to settle any dispute around the work's originality on a case-by-case basis. So that means the maker of the work has a lot of power, because not only does the party who would benefit from a copyright get to determine at the moment of its creation whether or not it's original, but they can also choose to not enforce the copyright against an infringer in order to avoid setting any negative precedent. So what does originality mean? Well, it all comes down to the scope of creative choices that are made during a work's reproduction or not. So in the EU, the standard requires that the work must be the author's own intellectual creation. But each member state always has its own national phrasing of that standard. So in the UK, it's skill, labor, and/or judgment. But because the EU has harmonized this standard, in theory, there should be no difference in substance between any of the member state standards, despite how they're described in national law. Which brings me to the last point. Copyright is territorial. And this is important to keep in mind, because a work that's in copyright in the United States may not be in copyright in the United Kingdom and vice versa. So this raises issues around cross-border dissemination and reuse. And it's especially relevant when we think about digitization and restitution, which I'll touch on in the second part. So you're probably thinking, okay, that doesn't sound like the basics at all. But it kind of is, and it's also very general because it gets way more complicated, especially when we think about the collections management aspects and the layers of rights that can attach over the years to various materials. So for example, if we think about this in terms of this flowchart, all the way to the left, we can see that we have the work itself, so the work of art or the cultural object. And the first question that we would ask before we digitize it is whether or not the underlying work is in the public domain. And if so, there's relatively little risk to reproducing that work. But given that the reproduction methods have only moved into digital in the past couple of decades, this means a lot of the reproduction materials that currently exist in collections are analog or material photographic reproductions. And that can be important when we're thinking about digitizing those materials as well, because it will add another layer of rights that we might need to consider. So for example, looking at the second column, we can see that the material reproductions or the photography might include a photograph of a 2D work or a cultural object, a 3D work, or even an exhibition of the work. And the more scope that there is for creative choices to be made within each of those photographs, rather than technical choices, the more likely the photographer is to have a copyright. So we would look to the place where the photographer chooses to stand, where the lights are positioned, and how they are used to create shadow or mood, and so on. And the more types of decisions we have like that are creative rather than technical, the greater the likelihood of the copyright. So by the time we get to the third column, which is when we start to think about digital reproduction, we need to think about that underlying copyright in the material reproduction, as well as a digital reproduction. But by contrast, we also might have born digital reproductions in media, in which case we would ask the same questions we might with the analog reproductions. But because the digital aspects and the technologies are used are more advanced or define certain parameters around the types of ways that an image can be captured, there may be less scope for creative choices to be made. But we do also want to think about what types of technologies are used in terms of digital technologies, because it, again, will make a difference whether the work is captured by a digital flatbed scan versus photography versus a 3D scanner. And then we have additional types of materials to consider as well. So if we look at the right, these are mainly in reference to archival mounts and curatorial records. So in other words, the analog data around the work. And depending on the type of data recorded, such as whether it's basic, descriptive, it expresses opinions, or even the arrangement of the data on the archival mount itself, there could be copyright in portions or the entirety of that mount. So then that has to be considered when we digitize and make that available. And even though we're just talking about copyright here, traditional artworks and objects and their reproduction materials, we should also think about the wider scope of GLAM institutions that are out there when we start to think about the underlying manifestation of the culture, so the source work itself, or when we're thinking about intangible cultural heritage and their records, because we need to think about things like performers' rights, database rights, patents, plant breeders' rights, rights associated with traditional cultural expressions, traditional knowledge, or even sui generis protection for genetic resources. So let's make this simple again and look at when copyright doesn't arise, namely when the digital media fails the originality standard. Except it's not so simple. Because as I mentioned before, the automatic and territorial nature of copyright allows the party who makes the reproduction to decide whether or not originality is met and whether copyright will be claimed. So here we have three very different reproductions of the exact same work. It's Gustave Le Gray's engraving of the Mona Lisa after Aimé Millet's drawing, which has been digitized and made available by three different institutions, each of whom have come to different conclusions on the question of copyright. But it's also not uncommon when we're looking at materials within a given institution for that institution to take different approaches. So for example, the underlying painting here is by David Hockney, and because it's still in copyright, Tate treats this digital reproduction as a copy and cites David Hockney as the copyright holder. But here, the underlying painting is by Millet, who died more than a century ago. So this painting's in the public domain. And somehow the exact same reproduction process has generated a new original work, which the Tate claims copyright in and licenses for a fee. Now that was 2D to 2D reproduction. What about 3D reproduction? Again, it can all depend on how the work is reproduced and the form of technology used. So photogrammetry uses a composite of 2D reproduction photographs of 3D works. Therefore, it's more likely that the 3D model will attract a copyright. The same goes for 3D illustrative modeling undertaken by a human operator. But by contrast, scanning is less likely to attract a copyright in the raw data. And we have a breadth of other composite or digital material generated that could attract copyright or not. Not to mention the added processes of post-production. So when we're thinking about basic or batch edits, those are probably unlikely to attract a copyright in the edited file. But globally, courts have been pretty silent on originality during the use of computer software to edit and enhance a digital file. And this could be explained by the law's exceedingly slow pace in comparison to that of digital and technological advancement. Because even the most recent case that we have on this, which is the Rice-Engelhorn Museum from 2018, it looked at analog photographs that were made in 1994. So while many countries recognize copyright in reproductions of 3D artworks, there's no consistent EU-wide or national treatment around semi-automated digitization processes, and these gaps are really relevant for this area. Even so, throughout the industry, creative choices are increasingly limited in other ways by industry-made best practices, by digitization guidelines and standardized methods, the lack of choice of what technologies are available because of what's provided by the institution, the lack of choice in subject matter and representation, and the list goes on. But one huge development in this area is Article 14 of the new EU Copyright in the Digital Single Market Directive. It states that for works of visual art in the public domain, any material resulting from an act of reproduction of that work is not subject to a copyright or related rights unless the material resulting from that act of reproduction is original in the sense that it's the author's own intellectual creation. Now, this will apply to everyone in the EU, so not only heritage institutions, but it is intended to ensure that no new rights arise in reproduction media in order to put everyone on equal footing when it comes to accessing and reusing the public domain. That being said, the text is a bit circular, but what it essentially means is that once a work of visual art passes into the public domain, any material resulting from an act of reproduction must meet the harmonized EU threshold of originality to be protected by copyright. And that's why it's circular, because it's essentially saying to be protected by copyright, a work has to meet the copyright threshold. And for most member states, this is already the law, meaning the majority of member states do not recognize related rights or these baby copyrights in such materials, and they've always required the works to meet the actual copyright threshold of originality to be protected by copyright, like the UK. But this hasn't stopped people from claiming copyright today. In fact, the argument has always been that the copyright threshold is met during reproduction, and we haven't had any court decisions to tell us otherwise. In fact, only Germany has binding authority that says copyright is not met in photographic reproductions of public domain works, which is the lawsuit I referenced earlier with the Rice-Engelhorn Museum. And that court held that a related right existed, but not a copyright. Moreover, the article only applies to works of visual art. So what is a work of visual art? Well, we know that it's not maps, scientific illustrations, sheet music, technical drawing, manuscripts, and so on. But what about artifacts, decorative objects? It's not clear. And then finally, in the UK, we have Brexit. So Article 14 won't bind the UK, and institutions, some of them have been pretty vocal about welcoming that. So what will happen to us? We don't know. So when we think back to what this all means, if something is in copyright, the rights holder can choose to do whatever they want with it, including releasing it via a Creative Commons license, or even waiving the copyright and making it available as public domain for anyone to use. But if copyright is not met, the work is in the public domain from the beginning, meaning no one needs to ask to use it or to use it for certain purposes. They can do whatever they want with it so long as that work is made publicly available for them to access. So let's very briefly apply this with a specific example, namely a 2D photograph of a 3D sculpture. So this image satisfies the threshold of originality because it's a 2D photograph of a 3D work that required lighting, potentially a lot of skill and judgment in order to make. So the British Museum has claimed copyright, and they've released the image under the closed Creative Commons license, which requires attribution, non-commercial use, and sharing alike, because they have copyright in the image, and they are entitled to do that. By contrast, the Met has digitized this work and released the image via a CC0 public domain dedication tool, and they've marked the work clearly as public domain for any reuse. So if I'm giving a paid lecture about Greek sculpture or this era in general, I might opt to use the Met's open access image rather than pay the fee for commercial use to the British Museum, which is important to keep in mind later. And an increasing amount of institutions are actually opting for this latter approach. So they're releasing materials for public reuse, and in fact, almost 750 have released either some or all of their eligible data for public reuse, according to this list that Douglas McCarthy at Europeana and I managed to track instances of open access. So why should we care? Well, this goes back to what either outcome means for the types of materials that we're talking about when we think about the restitution of culture, especially culture that's been taken illegally or during periods of colonial oppression. So copyright plays a crucial role here. First, the systems that will determine whether and under what circumstances copyright arise in material and digital culture are products of colonial histories, starting with the 1710 Statute of Anne, the first modern Copyright Act, and leading up to the contemporary copyright law. Copyright is a product of colonizers, and through various international conventions, it has been harmonized and transplanted into national laws worldwide and according to Western values. So this includes the systems regulating the underlying objects, which sustain ownership and control over the work's digital life. So these laws are also held up often as barriers to restitution. But excuses that the law doesn't permit restitution of looted materials are false claims. These laws are inherited and they can be changed. So one last example to kind of frame this when we transition into restitution aspects is this work that's held at the British Museum. So you'll notice that I've selected a print by William Hogarth. It's from A Rake's Progress. And Hogarth actually played a critical role in lobbying for the 1735 Engravings Acts, which extended copyright protection to engravings that were designed and engraved by the same artist for 14 years after their publication. So Hogarth's series passed into the public domain 270 years ago, but the public's ability to access and use this copy is restricted by the museum's copyright claim. And while we might enjoy a certain irony in the museum's perpetual copyright claim to every new Hogarth reproduction in the very country where he helped to formalize copyright law, this starts to change when we think about heritage from communities that have suffered from the effects of empire and colonization. And in fact, there are various digital versions of Hoa Hakananaya online, all of which are marked copyright trustees of the British Museum. And the museum's rhetoric and narrative around Hoa Hakananaya seems unfit for a moai that's described by the descendants as a Rapa Nui soul. So the moai is one of many works held by the museum that have been requested by descendant communities dispossessed of their culture during colonization. But on-site and online, exhibitions fail to acknowledge this. And instead, they print the moai as a gift from Queen Victoria. So a combination of legal measures are used to justify the possession and the commercial exploitation of Hoa Hakananaya, from the request notice in the gallery to the copyright notices online. And even though copyright is now global, we've not yet formed equitable principles to limit its reach when it comes to materials that may be inappropriate for copyright frameworks, let alone materials that fall outside of copyright's incentives and creation theories and public welfare goals. In fact, how might other rights limit or trump copyright and public domain law, as well as access in and of itself? How might the UN Declaration on the Rights of Indigenous Peoples, which recognizes the right of Indigenous peoples to maintain, control, protect, and develop cultural heritage, traditional knowledge, and traditional cultural expressions, as well as the manifestation of their sciences, technologies, and cultures, be relevant to redefining the limits of patent and copyright law and digital cultural heritage creation and management? So when we're thinking about the types of materials as manifestations of culture, even instead of referring to them as works, which is what intellectual property would call them, or innovations or inventions, this already helps us kind of conceptually move the materials outside of the IPR framework. And this can be especially important when we're thinking about the digital reproductions of manifestations of culture, or even funerary and spiritual objects or human remains. So this should be a central part of the debate around restitution, and specifically how intellectual property concerns are crucial to repatriation policies. but also how digital in and of itself might be considered alongside the material repatriation due to the complex IPR aspects involved. So at the moment, restitution is heavily focused on Africa and other regions with indigenous peoples. And this is in large part due to the November 2017 report that President Emmanuel Macron commissioned on France's potential for restitution of African cultural heritage. So scholars Felwine Sarr and Benedict Savoy published an extensive report making a number of recommendations for how restitution should proceed. And it provides an ideal kind of practical application for teasing some of this out. So the primary purpose of this 250-page report is to lay out the history and responsibility of France to exploited African cultures and the challenges that underlie physical restitution, its administrative processes, and repatriations. And there's a short section on the sharing of digital content on pages 67 through 68 of the English version that I'd like to focus on because it makes specific recommendations around the sharing of digital content. So for works already digitized, the report recommends a radical practice of sharing, including how one rethinks the politics of image rights use. And it promotes the creation of a single open access portal to documentation of African cultural heritage and associated materials and collections. For works not yet digitized, the report recommends systematic digitization following a dialogue between the institutions and the parties involved. So let's consider these recommendations, beginning with a radical practice of sharing. So on its face, we all want this because more open access is great, right? But the first issue is that if adopted by the French government, it will set a double standard of imposing open and free access to digital heritage collections of African cultural heritage, while the same obligations are not expected of French national institutions. So at the moment, only 19 institutions in France make eligible data available under open compliant licenses and tools. And 8 have adopted open access policy for all data, rather than releasing data on a collections by collections basis. But you still need to dig a bit deeper to each of the collections to see what types of data is made available and at what quality to get a more accurate picture. So this radical practice of sharing is not yet imposed on French institutions. And considering that intellectual property is a Western construct that carries its own colonial bias, it follows that the public domain and open access are also components of this colonial thinking. But let's also look closer at the politics of image rights use. So one of the museums that the report focuses on is the Musée du Quai Branly in Paris, which holds 70,000 sub-Saharan African treasures, representing about 2/3 of the African objects held in France. So according to the museum's digital and exhibition portal, it hosts 1,063,313 objects of African digital cultural heritage. And the museum claims copyright in all of it. So the politics embedded in this copyright secure to the institution the right to benefit economically from the object's possession and the exploitation of its digital reproduction. And the claim to intellectual property carries the ability to exclude others from accessing the digital collection's embodied knowledge. And it fortifies the effects of colonization by rewarding the rights holder with control over its access and reuse. But the report doesn't advocate for emptying the museums of these collections. It starts by identifying a group of works fit for restitution like the spin in bronze. And it highlights in many ways that African material cultural heritage has been exposed to a system of appropriation and alienation as a result of colonization. But it doesn't extend this system to considerations of African digital cultural heritage. Because the impact is that intellectual property extends to control over how the work has been documented and cataloged, how it has historically been exhibited, as well as contemporary forms of exhibition, how it has been merchandised through postcards, and who has economically benefited from its commercialization, how it has been redocumented under new technologies over the years, as well as authority, knowledge generation, and dissemination around the works, including presenting images of the ancestors as exclusive intellectual property. So due to copyright, digitization carries the ability to symbolically appropriate and control the knowledge, personhood, and objecthood embodied in the material works. And if the material work is returned while the digital materials remain in France, the digital materials will be alienated from the material work and the community seeking to reappropriate their own heritage. So considering that copyright is territorial, the report's recommendation around systematic digitization means that material culture will be digitized in France and trigger the application of French and EU IP law. But we should also question who is best placed to undertake this task and the systems of values that will inform this answer, because digitization in and of itself is not a neutral act. So we should critically examine whose needs are served by systematic digitization and explore how more nuanced systems serving the communities of origin might be established through collaborative work. So Andrew Prescott and Lorna Hughes have written a paper that argues for a slow digitization process. And this involves paying the same attention to the processes of digitization as we pay to the objects themselves, instead of rapidly digitizing cultural heritage to make it available online. And indeed, digitization, as well as presentation, access, and control, is a cultural and curatorial prerogative that should belong to the community of origin. It will impact how heritage is represented, preserved, and remembered. And legally, the reality remains that works like the Benin bronzes were looted. So the choice to digitize and how should therefore be held by that community. There's also the concern that restitution might be conditioned upon digitization for preservation purposes. But we should accept that some of the works may be lost, and that this need to preserve the work is rooted in Western practices around collections management and preservation. So Hamidi Bokwam, the director of the Museum of Black Civilizations, has said, the restitution of Africa's stolen assets should not be dependent on us having space to display it. Those who stole our assets cannot dictate what we do with them. For example, if a community wants to restore their assets to sacred forests from which they were taken, that is their right. And finally, all of us, for all of us, the creation of a new digital resource should sound familiar. We always want to go big. We always want to think about something new. And in this case, digitization can enable wider African communities access to the digital materials during the transition and even after restitution. But restitution itself is already going to be a huge and complicated endeavor. And we might consider looking to existing models of digital heritage collections, cultural data aggregators, and online platforms designed by organizations that have implemented similar digital portals. This is one of the reasons why citizen-led initiatives like Wiki and GitHub are really great platforms, because while they're not without their own issues of authority and gatekeeping, they enable communities to reclaim cultural narratives in native languages. But we also need institutions to play a role in helping to educate the wider public around sensitive treatment of heritage objects and to make sure that data sovereignty is respected. So all of this is included in a report that Mathilde and I wrote, which was signed by 108 academics and practitioners from legal and GLAM sectors. And it's been published as open access in both French and English in the Journal of Intellectual Property, Information Technology, and E-commerce Law. But we also argue that this rethinking should apply to objects not designated for restitution and highlight those working in this area. So the Auckland Museum has developed comprehensive cultural permissions policies in tandem with the communities whose objects remain in their care. And this is a real opportunity to invert the colonial hegemonic relationship that the report refers to around the treatment of cultural heritage, including the heritage that remains in situ with heritage institutions. The Qatar National Library has also worked with WIPO to develop an ethical terms of use policy, which forms part of the copyright policy. And while recognizing that the library may be the IP owner under national law, or that the works themselves may be in the public domain, it notes the broader rights and interests in intangible cultural heritage and traditional knowledge or cultural expressions that arise under national, customary, religious, or other practices, and seeks and requires informed consent from the traditional custodians before any commercial reuse of the purpose of the materials occurs. Which is really important to think about when we're thinking about the digital aspects, not only about the manifestations of cultures that are held by institutions, but also legitimately held in copyright or public domain works that are acquired, created, and donated by wealthy individuals who profited from and were responsible for colonization. So the British Library has begun reviewing pages in online collections owned by particular figures who obtained wealth via the enslavement of people and other colonial violence. But what about the new wealth, if we can call it that, that's generated through copyright via the digital materials of these cultural objects and the digital initiatives that are generated around them? Who should receive that? So this brings us back to these bronzes. So at the moment, digitization processes proceed under host communities' oversight. This is the status quo. So first, this precludes alternative conceptions of how heritage might be represented and presented to the public by the communities of origin. Just as there are different interpretations or conceptions of cultural heritage, there are different interpretations or conceptions of digital cultural heritage, as well as different types of engagement. But second, it precludes alternative conceptions of how they might be propertized and commercialized or not. Even if the general consensus is to enable free and unfettered open access, we need to critically examine the laws in place that will dictate how that proceeds. And regardless of where the physical manifestation sits, that decision should be made by the community of origin, especially considering that the history of these manifestations and how they came to be in the possession of Western institutions. So here we have two high quality images of Benin bronzes, which look visually similar, and both are made available for copyright free for any reuse. Now, these images would normally be protected by copyright because they meet the threshold of originality. But the CC0 dedication means that anyone with access to these images may now use them for any purpose, including the communities of origin. But if you go to Google Image and you do a search for the Benin bronzes, the first 3 returns are all openly licensed or dedicated to the public domain, which reflects their popularity through the algorithm. The rest in this first line are all protected by copyright, which the rights holder can choose to commercialize. But there's a follow-on detrimental impact here to the community of origin as well, because now that these copyright-free images are out there, it undermines the market by the Benin City National Museum, for example, to digitize and commercialize its own culture upon restitution. Moreover, the host institutions have commercialized and benefited from licensing the reproductions of these and similar works for decades. So as institutions increasingly go open access with their collections, decisions by the communities of possession will have follow-on impacts for the communities of origin on how they might reappropriate, represent, reproduce, generate, and license new works around their repatriated cultural heritage. So ultimately, intellectual property is this Western construct that carries a colonial bias, but the risk here is on digitally imposing Western perspectives of how IP should be exploited or not, and how access should be extended to this cultural heritage. So perhaps we should start by viewing certain materials as falling outside the intellectual property and digitization works entirely, or at least designing new approaches with communities of origins for how their cultural manifestations might be digitized, published, and commercialized, including who should receive the revenue. So this brings me to the concept of IPR repatriation. So one thing that digitization is not, which Sarah Bond has written about, is a substitute for repatriation of the cultural manifestation. But let's tease this out a bit further. By focusing on the repatriation of IPR alongside restitution policies, sometimes national law must be changed in order to enable the physical repatriation, or the community of origin might even consent to allowing that manifestation to remain in custodial care of the GLAM. So in these cases, IPR and the existing reproduction or associated materials can be transferred to the community of origin, set aside, or even waived by the GLAM institution themselves. Where appropriate, the IPR can be commercialized, with any economic benefits flowing to the community of origin. And agreements should also be formed around future treatment, including whether digitization is appropriate or not, even for archival or preservation purposes, as well as agreements around digital surrogates, access and reuse, including cultural permissions, non-open access, or even access restrictions. And as part of this, GLAM should consider and discuss whether the copies themselves can be retained and reused, if so, for what purposes, or whether the digital and analog reproduction and associated material should also be restituted and any copies withdrawn from GLAM collections as part of this process. So Matilda and I have written on this topic too in a response to the UN expert mechanism request for comments on the repatriation of ceremonial objects and human remains under the UN Declaration for the Rights of Indigenous Peoples. Because regardless of whether the work is in the public domain, there are a number of questions that we need to be asking to inject more ethical and equitable relationships into the creation and management of digital cultural heritage, which are directly related to the physical manifestations of the culture themselves. So these might not be directly related to IPR on their face, but they do relate to the automatic nature of copyright protection, its territoriality, the possession of the work, the legal systems, and the systems of values that will inform how both the digital and physical materials will be treated by property and intellectual property law. And considering the very long term of copyright, outcomes could impact an entire generation. So while these ethical questions are becoming more relevant to ownership and possession, they've yet to permeate areas of IPR and open access, or even acts of digitization under non-IPR related access. This month, the Denver Museum announced that it would return 30 carvings from the Mijikenda people of Kenya and northern Tanzania, which embody the spirits of ancestors who have died. And in an article about the decision, the director of anthropology commented, "We should not be curating people's souls, but should we be digitizing and publishing them either?" In the UK, the Arts Council England has issued a call earlier this year for revised guidance on restitution and repatriation for UK museums. It was awarded to the Institute of Art and Law, and it should be published soon. And in a scoping study that I did with my students in art and law, we surveyed around 60 institutions in the UK with relevant collections and learned that a range of approaches were being taken around the digital and IPR aspects of manifestations requested for restitution since 2010. So we just looked at a very narrow set of repatriation requests, restitution requests since 2010. And for the most part, digital and IPR was not on anyone's radar. But again, because we respected information with such a small subset of manifestations, it could be that these things have been considered with manifestations prior to 2010. Even so, a few institutions noted they just didn't hold digital assets for the relevant manifestations of culture. In other cases, digital copies were made and both retained by the institution and returned with the physical manifestations. In one case, the relevant record photography was removed from the institution's database. Some were not returned, but the institutions refrained from licensing them and sometimes restricted access to them in the first place. And in one case, images were licensed, but we were reassured that they weren't used on merchandise products. So only 2 institutions could report how much licensing revenue was generated via the specific digital images of the objects that had been requested for restitution, both of which were paintings, and which amounted to less than £500. But that's likely because most institutions don't track this type of data at an item level. Still, we thought we'd ask. Overwhelmingly, though, institutions claim copyright in these materials if they have them. And even if they don't share them, they claim copyright. So this aspect of why the copyright is important, what relationship it has to the digital materials, how those digital materials are related to aspects of repatriation, and including IPR or exploring IPR repatriation is something that's largely not being explored. So as we rush forward to satisfy expectations around digitization, access, and reuse, especially considering the potential global reach of digital collections, we really urgently need to be thinking about a more critical approach to digitization and open GLAM. And that includes questioning whether the materials are suitable for access, let alone open access, as well as what it means to claim copyright in and commercialize the collections that have been removed from their origins, often through colonial violence. But it also requires us to ask whether or not it's necessary to digitize them. And if the answer to that is yes, we should ask whose systems of values are informing that answer. But this also requires us to critically examine the legal and social systems that we've inherited, who they benefit, and to challenge their broad application as the world becomes increasingly globalized, especially in the digital realm. So thank you.
Thank you very much, Andrea. That was really, really interesting and fascinating. And I really hope that there were a few people from the GLAM sector in our audience. And by the way, if you have questions for Andrea, please use the YouTube chat. I see that we have some already. But if you're there, you're listening, you have some doubts or questions or comments, please just use the chat. I will start asking the people in the call if they have questions. I just wanted to thank you, Andrea, once more. And I really have a lot of comments, but I will be nice and let someone else start. I just wanted to stress how important it is to start thinking of digital culture heritage as culture heritage. And how much just specifying that it is digital is slowly losing its whole meaning. It is just part of culture heritage, and we need to be as thoughtful, as careful about digital cultural heritage as we try to be with the material one. Who wants to start with question or comments in the call?
May I start?
Absolutely, Usama, please do.
Thank you very much, Andrea. It's been overwhelming. I like the connection you made between decolonization and westernization and other things, and Western value and how copyright and all these things. And it's a very complex issue, as you say. I think in your earlier presentation, you talked about how decolonization became a metaphor for many things, and now you are trying to dissect all these things, which seems very complex issue, and also like your approach of how this has to do with agreements and policies of repatriation. And from my own place, in Egypt, there is a lot of relevant material here, starting from Nefertiti bust in Berlin and Rosetta Stone in the British Museum, and the 3D modeling of these, and whether they are copyright of these museums or they are copyright of Egypt or the Egyptian people. And this brings us to the what you said about the value, the system of values. Are Egyptian indigenous people or not? Because again, do they have a culture heritage that they have to, repatriate and other things, or are they not defined as an indigenous people with culture that has been appropriated during the colonial era? So, speaking of papyrology and papyri and the collections and how the benefit has been from these collections. Just imagine if there is no collection in Europe or the States, there will be no students, no research, nothing, if they were repatriated to Egypt. And that makes it difficult to negotiate, to start this line of negotiation with collection and other things. So how do you see this in the future when there are this economical obstacle and intellectual also? Again, if you look at the history of these disciplines, you will see, we are the custodians of knowledge, we know more, we have saved this, and so on. This tropes and rhetoric and cliches. So it's how you see how we can proceed in this when you ask and they say no, we can't give it back because so and so, and we have been talking about the GEM, Grand Egyptian Museum, and other museums that are now in Egypt. And so how you see it?
There's about 40 questions in that. But I mean, so I think I'll touch on a few of the things that I agree with you with. And I also think one of the things that we often do when we're talking about some of this is we start to think about the other extreme, which is what happens when we return everything. And people no longer have access to that in different areas of the world. And first, I don't think that that's realistic or will ever happen. And it's not necessarily anything that anyone is requesting, but there are individual requests by communities who are descendants of some of the cultures that have been collected and treated as knowledge specimens. We start to think about, especially some of the sensitivity where we can get into some of these materials, and especially you start to think about the legal systems and the standards of evidence, the definitions even of indigenous peoples that people will have to meet in order to make the claims, and for those claims to be valid under the legal systems where the objects sit in the first place. So there's a lot of kind of embedded power inequities and questions that we would want to ask in terms of why do we even have to accept the law as it is and as it stands if it's preventing some of these types of really meaningful repatriation and restitution initiatives from going forward. It's also kind of an approach in terms of this monolithic understanding of what knowledge is. We can engage with works. We can, potentially destroy them. There can be multiple ideas of what knowledge is. Why is our study reserved to treating the object as something that no longer has a life or a purpose other than to be looked at and objectified? So there's other ways that, we can engage with culture and we can learn that don't, approach this idea of a universal knowledge, even the expectation that we are entitled to someone else's knowledge or someone else's culture. And this is something that I see as a really interesting parallel when we think about intellectual property, because copyright is default. It arises the moment that something is expressed in a material form. And while most of the objects, most of the works, most of the culture, or even when we think about traditional knowledge and traditional cultural expressions, are either in the public domain or they have specific laws that have been carved out for them because they don't fit within the copyright framework, right? When we start to think about then who controls access to all of these various things, copyright doesn't have to be default. The laws that control these things don't have to be default. We're able to work through agreements that are more equitable and take a lot of other understandings of knowledge and access into account, and even exclusion, right? So not copyright forms of exclusion, but cultural exclusion. And so I think this is an area that, there's a lot of room for reflection and growth in, and I don't even necessarily have the answers because I am obviously a white person who is not of an indigenous culture, but I am from a culture that oppresses people with copyright, right? So this is the way that I start to think about how I carve out and limit what's going on within the system that I have inherited and that I think should change and be more adaptable. So I'm not sure whether that answers all of your questions, but I think it was a great comment as well.
I think that was a very good start. I will read some of the questions that were asked online, and I think that we had a couple that came in while you were walking us through the maze of UK copyright. So I think that there are, just some questions that are really, really curious about, all the exceptions and things like that. And I'm afraid I'm going to skip question because it's a little bit vague and it was referring to a particular moment of your talk that we cannot identify. But I'm going to read this by, I hope I'm reading this right. I hope this is Elena. Apologies if I am mispronouncing your name. So it's a multi-part question. So I'm going to read it all first. So how would you approach the copyright of digitized unpublished material? For example, which has not yet received a proper scholarly description/edition. So we have more examples. For example, a photo of a papyrus with some text is put online by a museum, and I would like to cite it or perhaps even decipher the text of the papyrus in my own scholarly work. Wait for it. In this case, thus the copyright of the museum concerns only the photo itself. I'm not allowed to reproduce it without permission, obviously, or also the object / the text on the object that I can see on the photo. So I can use this photo in my research tool, even if I only cite or describe it without reproducing the photo. This is the end of the question.
So this is really interesting for multiple reasons. One is that, depending on the text that's being cited, it could be pictorial. So there may be a reason for wanting to quote this specific text in its original form, especially when we're thinking about translation. And it could be that the institution's translation of that text could be translated or interpreted in more than one way, right? So we have the image itself and we have the text that's embedded within the image, but then we also have the translation of that text, which could potentially receive a copyright as well, because the text itself will be someone's informed interpretation. Maybe they've made certain decisions around this phrasing or this terminology or that as in and of itself. But what's important to that is the quotation exception. So in each national copyright law, there will, well, not each, but in many, there will be the quotation exception. And a lot of scholarship has been trying to push and argue people toward the image kind of area of quotation and thinking about what does it mean to cite text, text from a book, even text that's in the public domain, versus an image when you have to cite the exact words, even if they're in copyright. Well, if the image is in copyright, is it not a quotation to include an image if you're actually referring to the image itself and something within it, right? So then we look to the national copyright laws to see how that's constructed and whether the use would actually be appropriate, because, there's still parameters around that as well. But the papyrus and thinking about hieroglyphics and thinking about translation is a really interesting and embedded question. And I think what it also highlights is the fact that we really need cultural institutions to make things available so that we're able to expand our own scholarship and use those works without having to constantly pay for them, because it does become something that could be potentially really expensive for people who are doing historical research or art history, needing to use the images. It becomes, something that can be in kind of impede even the publication of a work itself. And there's a really great article on this. I think it was published by Times Higher Education by Professor Catherine Rudy about specifically what she has had to pay over the most recent years in terms of licensing fees, even depositing a copy of every single book at all the institutions where she's used an image from their collection, all of these kind of sorts of additional fees that factor into just being an art historian. At the same time, the argument is always, we need money, which is true, right? We need, cultural institutions are totally underfunded. There's also a lot of research that says that image commercialization is not actually profitable when you take into account the overheads, the cost of, running that entire operation. But really that should be something that the government picks up, right? We just need governments to fund cultural institutions better, to give them more money. So, I think I can't obviously give an exact, especially legal advice, specific answer on that, but it's a great question.
Great, thank you, Andrea. Shall we take another question from our virtual room? I'll go if no one stops me. Okay. So I had a question. Actually, it's more of a request. If you can say a little bit more about the metadata of the digitized artifacts and images, because it struck me that, for example, a French museum that is digitizing this Benin artifacts or Algerian artifacts or whatever are not only, exerting some sort of, power over the material culture of another population, but they're also defining it. I mean, it feels to me that it's not just putting the image online, is how you call it, how you define it. So I would like you to know what you think about that.
So if I can just ask for a little bit more clarification, do you mean like the metadata that's associated with the digital file and what is chosen in terms of what gets attached? So this is interesting too, because, you know, when we think about collection management systems and digital asset management systems from, you know, internally from the back end, we know that there's a lot more information that's sometimes stored with the digital file that potentially could be embedded in the asset before it's made available online. There's also the metadata that will automatically be generated depending on the technology that's used. There's basic descriptive data that someone might insert, you know, through Adobe Bridge or some other sort of program that can even be applied as a template, right? So some of this data will be computer generated. Some of it will be super descriptive and basic and not copyrightable in and of itself. Some of it may actually be somewhat proprietary when we're thinking about the different types of metadata that can potentially be attached. But then it also might extend to curatorial opinions that you could put with the image or not, right? And so a lot of institutions, because they want to release their metadata CC0, which is the public domain dedication, will restrict the amount of information that they actually attach to the image, because some of that stuff, if it's created by the curator and depending on the jurisdiction where someone sits, it could remain with the curator in terms of the moral rights to be attributed as the curator who put that information into the system that then follows the image. And so there could be some risk in making some of that curatorial opinion or even more basic paragraph style description about the work available, which is a shame, right? Because often when we think about, you know, the context that can travel with it, the richer the data, the better, you know, the semantic web works, the better we can like make linkages between certain things, and hopefully it will follow and carry with the image and preserve some of the educational context. So I'm personally not sure what some of the solutions are, you know, with that respect. I think that there's a lot of risk aversion within the management of cultural materials that could be challenged a bit. Especially when we're thinking about employees and people who work within a public institution, thinking about, you know, what rights should follow and be attached and even potentially waived when we're managing cultural data. But then it also, I think, plays on a different part of your question, which is about the narrative that potentially follows that image and is seen as authority. And so I know that there's a lot of really interesting projects going on that are about co-development of knowledge or even multivocality and allowing different layers of descriptions to be able to be attached and accessed through an image in the process, which I find really interesting.
Yeah, be very interesting to compare, you know, the descriptive metadata that are produced by different, you know, subjects and communities, because, you know, descriptions are not objective. So that would be a good point. Okay, I'm gonna move to another question from our YouTube audience, and G Hill is asking if there are any examples of laws that have been changed to benefit descendant communities whose heritage is being digitally reproduced. Give us some good news, please.
So yes, there. You know, what's interesting is cultural institutions have been really innovative about working through some of the legal inflexibilities because of the way that, you know, copyright might arise or might stand. And there's also been legislative reform around how we recognize copyright rather than in an author, but in a group or a community. So two jurisdictions that I would recommend looking at are Australia and then also New Zealand. And I cannot stress enough. I stare at New Zealand and I look and I see what they're doing, and it's always amazing. And I'm just like, so a lot of what they've been doing is thinking about how we just kind of set materials outside of copyright and access frameworks, which has, you know, been really informative into a lot of my research too. and who's able to access. And I know that there's a lot of institutions that will do that, depending on like the specific community and the manifestations of culture that they hold, especially with First Nations or Native American communities. But yeah, in terms of a broader, like huge kind of international legislative measure, not necessarily, but UNDRIP, which is the declaration that I referenced, is touches on this and looks into this and makes obligations for states to actually change portions of their law so that this becomes more accessible. But again, it then kind of depends on how it's formulated on a national level. And yeah, so I guess I'll stop there because I could keep going about traditional knowledge and traditional cultural expressions, but.
Thank you. I think we are slightly overrunning, so I'm going to hurry up a little bit with the questions from our audience. We have another one from Carla Schur. I renew my apologies for every mispronunciation of surnames. And she's saying, because of digital colonialism, our organization focuses on training local and indigenous communities to do their own photogrammetry and photography, so they have control. And Carla's organization is the Culture Heritage Imaging, which is quite a cool organization, actually. So I don't think this is really a question. She's also saying that this is a fabulous presentation. So
thanks, Carla. I just took a screenshot, so that way I can look up cultural heritage imaging after this is over.
Do we have any final question from the room? Hannah, please.
Hi, so I was wondering, this is kind of along what Valeria was saying earlier, and you touched on this in your presentation as well. But when it comes to like not just the metadata, but also like the images that museums hold that they don't put online, they don't publish, the ones they take for themselves, and then like the research they do as well to like track down every time it's been mentioned, all of that kind of stuff. What is the ideal with that if you are repatriating everything and the digital? Like, should they be able to hold on to it? Like, is it ideal for everyone to have access to that? Like, should it be out there anyway? I don't know.
I mean, that's the question. And I think depending on the communities that are associated with the culture, they'll have completely different responses for whether it should be digitized, whether, and for what purposes, whether those copies remain internally, whether they are made available externally, and if so, under what permissions, or even whether they will allow for copyright to be claimed and for it to be, so we keep going a bit further and further and further down till we get to the point where there is no copyright and we allow this to be in the public domain, therefore other people can use it. But there are questions around also who should be making that decision even within the community. And I think the main point is we just have to withdraw our tendencies and challenge them to reinforce a status quo around how some of this proceeds. So it really is about shifting power, shifting decision-making, being okay with not having control over the outcome or even being happy with, what the decision is that's made. And that's, again, from the perspective of all of the knowledge production and collections heritage management that is embedded in the systems that we have all been educated within. Like it's a natural resistance. You start to think, no. But I think that's where actually the most interesting kind of, I wouldn't call it a conflict, but kind of shifting of boundaries, right, starts to then occur where you even understand how your own mind has started to conceive things in a specific way that resists alternative notions and narratives.
Thank you.
I didn't actually have a question. I just wanted to say thank you very much for the lecture. It was super interesting. Gave me a lot
love
to
your
think about.
question.
Yeah, thank you. Great. But yeah, no, thank you.
Right. It's a little bit late, so I think I'm allowed to a silly comment, which is that repatriation has proven to be such a fertile soil for comedy if it were not, so tragic and infuriating because it's just absurd. And this let's give away all the digital rights sounds really like someone that yes, I'm gifting you something that is not even mine, which if it were not tragic would be quite ridiculous. But that's actually how it sounds from the outside. Do we have any final comment? I see a few, thank you, we enjoyed this very much, that I hope Andrea will be able to read after we go offline. Anything from you, Gabby? One last comment, observation? Not really. Okay.
The only thing I would add is just, I mean, this is not doing much more than paraphrasing a small part of Andrea's last set of comments, but there is and should be an increasing movement internationally from UN, UNESCO, international groups like that to encourage, and they don't really have the power to enforce, but to the degree that they do in terms of conventions and funding and that sort of thing. The access to heritage, including digital heritage, and that sort of thing, and that is as it should be. And these should be international standards and agreements that apply to everybody. And there's a great difference, of course, between that and that being de facto imposed by someone who just happens to have stolen your heritage. I mean, there's a difference there. Yes, we want all this stuff to be online, but there's which way round does it go? And the international standards having slightly more teeth is probably the way to go, rather than saying, well, no, we can't repatriate this because they won't look after it.
I agree, and I think when we think about what even an appropriate international legal measure would look like, we then start to think about questions of retroactivity and all these concepts that, again, are totally framed within limiting and defining and drawing lines. And this is such an area that, and it's all based in territoriality. Each member state has to sign on, in order for, and then potentially implement it domestically. So there's still a lot of kind of colonial processes that then become embedded within something like that. And it's just, I mean, it's how do we do it? We need it, but yeah, I agree.
Okay, then I think we can close with a comment from G. Hill again that says, if the government and institutions benefit from the culture, it's time to pay. And I like this to be our closing comment. I would also like to thank Andrea once again. This was really interesting, and thank you for taking all our questions. And I'm sure we will talk more about it with Usama and Ali and Hannah and Gabby and everyone else. So yeah, you'll probably hear more from us. Thank you also for transforming what should have been your keynote into a public lecture so that everyone could benefit from it. And also thank you for helping us framing digital technologies, especially 3D technologies in our case, into something that is not just technical, is not just a technological training, but it's a reflection on the digital as as an object, as an entity, and how digital objects require ethical reflection and legal reflection. So thank you everyone for joining us, and thank you, Andrea.
Thank you. Well, thank you for having me.
Bye. Virtual clap.